This is Michael Popak, Legal AF. What do Harvey Weinstein and Donald Trump have in common? The new decision by the highest court in New York to reverse the conviction of Harvey Weinstein based on a misapplication by the trial judge of certain rules to keep out certain types of prior bad act evidence is bad for Donald Trump because Judge Merchan, presiding over his case, got his rulings exactly right. And now we see the wisdom of Judge Merchan's rulings because we see what the Court of Appeals, ultimately his bosses, have done in the Weinstein case. I am going to break it all down for you here on this hot take. Let's start with Weinstein, then I'll move to Trump and Merchan and tell you why Donald Trump's ability to appeal any conviction that results from this trial in New York for election interference and Stormy Daniels, and it's looking more and more likely that it's going to be a conviction based on the compelling evidence that's already been presented, just with witness number one, the roadmap witness, David Pecker. But I'm going to look at the decisions made by the judge before the trial even started to insulate his and the jury's ultimate verdict from any reversible error on appeal. And the Weinstein case gives us that guide. Harvey Weinstein, disgraced movie producer who is alleged and has been convicted or was convicted twice in California and New York of multiple counts of sexual assault, sexual abuse, and rape against women. His 16-count conviction in California still stands. What just got reversed this week in New York by its highest court, the Court of Appeals, is a 23-count conviction for him attacking 3 women and sexually abusing them. The problem that the Court of Appeals had in a hotly divided panel, full en banc, meaning the full panel of the Court of Appeals, 7 justices, it went 4-3 in favor of Weinstein, if you will. But at the heart of it is things that matter in the Trump case. What they had trouble with, and what is now the new law in this case of Weinstein, which was brought by the Manhattan DA's office, the same DA's office that's prosecuting Donald Trump, although it was done by Alvin Bragg's predecessor, Cy Vance, in his office, is that you can't bring in prior bad acts if the sole purpose of you ultimately using it is to prove a propensity to commit other bad acts. Let me repeat that. You can't bring in a list of other, in this case, women, or other witnesses to testify that me too, we were also attacked sexually by Harvey Weinstein, because all that does is tell the jury this person has bad character, which undermines the presumption of innocence, and it's only showing a propensity for him to commit a bad act. It's not probative of his innocence or guilt on the actual victims that are in the case before him. And that's the problem. In New York, they call it, based on a line of cases starting with Molyneux, they call it you can't bring in Molyneux evidence because Molyneux evidence is just being used to say, this guy's a bad guy. He's done bad things in the past. He must have done this bad thing now. Now, people might think, well, isn't that relevant to know the pattern of this person's behavior other than in this case? And yes, it is relevant, but it's also prejudicial because the innocence of the person has to rise and fall on the evidence and the facts about the victims that are in the case in front of the jury. And so that's the struggle. Now, there are exceptions to the Molyneux rule, which are noted by the Court of Appeals in New York, but I really want to focus on another rule in New York. It comes out of a case called Sandoval. It's the Sandoval disclosures. The prosecutors are required in New York to inform the defense so they can make the decision whether to put the criminal defendant on the stand, waive his Fifth Amendment right. They give a list of other bad acts, other charges, other crimes, if you will, that could be used against the defendant if he takes the stand, only if he takes the stand. And I said at the beginning that Judge Merchan did a masterful job at handling the Sandoval ruling about what could and could not be used against Donald Trump if he takes the stand. Now look, some people said, oh, there were a number of things on that list for the prosecutors in the Trump case. We wanted them to be able to use a cross-examination. But I said on Legal AF and in other places that this was a masterstroke by the judge to avoid reversible error on appeal. And now we have the Weinstein decision that tells us that he was exactly right. Let me first tell you what was wrong about the trial judge, not the same judge, Merchan, in the Weinstein case, and why it became reversible error, and why Weinstein is, I wouldn't say he's a free man, because the Manhattan DA's office, now led by Alvin Bragg, is going to retry and re-indict and retry him on that. They'll just leave out the evidence of all the other people that came in to testify against him that they #MeToo, we were also sexually assaulted. Sometimes I wish we could have things in life both ways, like a great glass of red wine, but without the headache. Well, that's not going to happen in that example, but it is possible to have it both ways with Mack Weldon. I know men tend to think looking sharp means starchy Oxfords and stiff chinos, rather than effortless comfort. But it's possible to have it both ways with Mack Weldon. Mack Weldon makes timeless apparel with modern performance fabrics for guys who want to look and feel sharp without sacrificing comfort. From their light as air underwear to innovative anti-odor tees and versatile yet comfortable pants, Mack Weldon has a full range of clothes that never go out of style. I love my Mack Weldon Ace sweatpants. They're incredibly comfortable and also very sharp looking. I have a real confidence boost knowing I'm wearing anything sold by Mack Weldon. Some guys just want to look good without calling attention to themselves. Mack Weldon apparel gives you understated good looks for understated confidence. Mack Weldon clothes are designed to fit your style and the demands of modern life. They look like regular clothes, but feel like the latest in modern comfort. They're the go-to choice for guys who want to look great without even trying. Get timeless looks with modern comfort from Mack Weldon. Go to MackWeldon.com and get 20% off your first order with promo code LegalAF. That's MackWeldon.com, promo code LegalAF. In the Sandoval application, which is the government telling, the prosecutors telling the defendant, if you take the stand, this is what we're going to bring against you. This is what the judge in the Weinstein case allowed to be disclosed. In other words, he approved the use of this information in cross-examination if Weinstein took the stand. And based on it, Weinstein decided not to take the stand. Here's the list. The prosecutors were permitted to ask about whether defendant directed a witness to lie to the defendant's wife, that's Weinstein, filed an application for a passport using a friend's social security number, whether Weinstein told a woman he could harm her professionally, but could also offer her a book publishing opportunity, whether Weinstein used his entertainment company, Miramax, and their budget for personal cost, whether Weinstein withdrew from a business deal and asked others to cease its funding, whether Weinstein hid a woman's clothes, insisted that members of his staff falsify a photo for a movie poster by photoshopping a female actor's head on another woman's nude body, whether Weinstein told a private intelligence firm to manipulate or lie to people, and whether he scheduled a meeting in 2012 with a woman under false pretenses, and so on. And the judge said, sure, that seems all fine. If he takes the stand, you can ask him all about that. And the Court of Appeals has now said, no, that wasn't fine. And that discouraged him from taking the stand, and he had the right, if he wanted to waive his Fifth Amendment privilege, to do that. Compare that now with the Sandoval ruling by Judge Merchan. And I'm going to go through it now and tell you why it almost like anticipated. Because a lot of people are like, oh my God, Weinstein's conviction got overturned. People that were very close to the issue and lawyers who practice like me, who had looked at the issue on appeal, were very concerned about what the trial judge, not Merchan, had done in that case. Now let's talk about Merchan, the Trump case, and why it matters to Trump. And he just lost the path for a reversible error on appeal because of how Judge Merchan handled it. As to the E. Jean Carroll case, the prosecutors wanted to put on evidence of the fact that Trump was adjudged to be a rapist, a sexual abuser, a defamer, and a punitive damages. The punitive damages were awarded against him. Judge Merchan said yes on the judgment against him for defamation and punitive damages, but do not mention the sexual misconduct or the sexual attack on E. Jean Carroll. And now you can see why, based on how the Court of Appeals just handled the Weinstein reversal on appeal. As to the New York Attorney General civil fraud case, which is not uncharged, it did go to judgment against Donald Trump. everything about the New York civil fraud case is going to be able to come in, and Donald Trump will have to be cross-examined about it if he takes the stand. That includes the $465 million judgment, him violating the gag orders, him being found to have not told the truth when he testified about attacking the principal law clerk. All that comes in, according to Judge Merchan, if Donald Trump takes the stand. But listen to how careful the judge was on the next one. Prosecutors wanted to bring in evidence that Donald Trump's companies, for which he led, were convicted of 17 counts of fraud and business record fraud, very similar to what's going on right now in the courtroom on business record fraud. And the judge says, yeah, that's too close. No, that's going to blow the jury's mind. That sounds like inappropriate propensity evidence, that he has the propensity to commit crimes and bad acts, rather than having his conviction here rise and fall on the evidence as presented in that courtroom. So no on that. We were like, although I thought it was the great ruling. But of course, we wanted the jury to know that he's run other fraudulent companies that have got convicted of crimes. But there, the judge used proper gatekeeping function, consistent now that we see with the Court of Appeals decision in Weinstein that came out 2 weeks later. And then finally, the judge said prosecutors wanted to cross-examine Donald Trump if he takes the stand on the fact that he filed a meritless bad faith lawsuit against Hillary Clinton and the Democratic National Committee and others, and that he got sanctioned $1 million and a bunch of findings by federal Judge Middlebrooks down in West Palm Beach. And the judge says, yeah, we're not letting that come in. And there were a lot of great quotes in the Middlebrooks opinion against Donald Trump and his political vendettas that masquerade as lawsuits that we wanted the jury to hear. But let's give props where they're due. Judge Merchan made the right decision. And now, when you take his decision about this Sandoval evidence that can only be used against Donald Trump if he takes the stand, and lay it as an overlay on top of what the Court of Appeals just did in Weinstein, Merchan was dead right. And now we're leading. There's no perfect trial, but what you want to try to avoid, you want to have a reversible, error-free trial. You want to remove those things. And right now, I haven't seen a darn thing that Merchan has ruled upon that would give rise to reversible error. And that's something 2, 3, 4 years from now. But it's important that the case proceed and be built without having error, right? There's always appellate issues. Especially when you're desperate like Donald Trump. If he's been convicted here of felonies, he's going to be desperate. But you want to just, every time there's a decision that gets made, it gets made by a trial judge like Merchan in a way that doesn't open the door to reversible error of an eventual conviction, which is likely in this case. I'm going to continue to follow. When I see an issue that maps directly onto the Trump criminal trials, I'm going to bring it to you here on MeidasTouch, on YouTube, on Legal AF, our podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time that I co-anchor. If you want to find out why we call it Legal AF, come join our show. You'll find out. And also, we put it on audio podcast platforms of your choice. If you like what I'm doing, I'm Michael Popak. Give me a thumbs up. Leave me a comment. It really does help with the quote-unquote ratings. It's not ego. It just sort of keeps the content on the air. And then you can also go over and find my body of work on MeidasTouch YouTube under contributors or under playlists. Look for Michael Popak. I got about 1,200 of these hot takes right here. And you like hearing about the law and how it applies and maps onto politics at the intersection, then join our new Legal AF Patreon, patreon.com/legalaf. For the cost of, a cup of coffee or a couple of cups of coffee a month, you'll get tutorials, teachable moments, really made for the non-lawyer, but the lawyer alike. We make it fun, we make it entertaining and informational, only on patreon.com/legalaf. So until my next hot take, until my next Legal AF, until my next Patreon exclusive content, this is Michael Popak reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.